This video examines the Supreme Court case of Mutya Sumilhig versus Sumilhig, decided by the Second Division in 2022. We will explore the court's ruling on psychological incapacity under Article 36 of the Family Code, specifically focusing on the application of the Tannendahl precedent. In this case, the Supreme Court clarified that a direct medical or psychiatric interview of a respondent is not mandatory to prove psychological incapacity. The court reversed lower court rulings and declared the marriage void ab initio, citing the husband's antecedent, grave, and incurable personality disorder. The parties met in 1984 while working at a restaurant. During their courtship, the petitioner observed the respondent's Chevy drinking and habitual gambling. Following the petitioner's pregnancy, the couple married in 1987 and had 2 children. Following the marriage, the respondent stopped working, gambled away savings, and was abusive toward the family. In 1990, the petitioner left the marriage. Upon retrieving her daughter, she discovered the child had been burned by the respondent. The respondent later abandoned the family to live with another woman. A psychiatric evaluation diagnosed the respondent with antisocial dependent personality disorder, comorbid with alcohol dependence and pathological gambling. This was attributed to a troubled childhood, characterized by a lack of discipline. The condition was found to be grave and incurable, preventing the discharge of marital obligations. Both the Regional Trial Court and the Court of Appeals originally denied the petition for nullity. They characterized the respondent's behavior as mere refusal or neglect, rather than a psychological disorder, and discounted the psychiatric report because the respondent had not been personally interviewed. The High Court reviewed 2 primary issues. First, whether the lack of a personal examination of the respondent invalidated the expert evaluation, and second, whether the totality of the evidence successfully established psychological incapacity under Article 36. The Supreme Court reaffirmed its doctrine that there is no legal requirement for a respondent to be personally examined by a physician or psychologist. Experts may instead rely on collateral information from those who closely observe the respondent's behaviors prior to and during the marriage. Post-Tannendahl standards clarify that psychological incapacity is a legal, not a medical concept. Expert testimony is not strictly mandatory. Evidence from ordinary witnesses who observed the spouse's behavior is sufficient. The required quantum of proof is clear and convincing evidence. The court applied the tripartite test. First, juridical antecedents, as the respondent's behavioral issues predated the marriage. Second, gravity, shown by his total failure to fulfill duties. Third, legal incurability, as his personality structure persisted across decades and different relationships. Ultimately, the Supreme Court granted the petition and declared the marriage void ab initio. A key takeaway for trial courts is to avoid the automatic dismissal of petitions solely due to an unexamined respondent, acknowledging the value of evidence from family members. Thank you for watching this lecture on the Mutya Sumilhig case. We hope this overview of Article 36 and current legal standards has been helpful. This video utilized images from Wikimedia Commons for illustrative purposes.